Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering acquitted Yale student files defamation lawsuit against 15 women's rights groups. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from the New York Sun, former Yale student acquitted of assault files defamation suit against 15 women's rights groups. A former Yale student, Saifullah Khan, who has become a poster boy for fighting back against Title IX and the excesses of the Me Too era, is now suing 15 women's rights organizations and an attorney who aided his assault accuser. Mr. Khan was accused of assault in 2015 by a classmate at Yale, but he was acquitted of all charges in 2018 in a criminal court, so he went through the criminal process, which does not always happen in these situations. Went through an actual court of law, not just a Title IX proceeding at a college. And he was found by a jury of his peers to be innocent. But even a little bit beyond that, so we know what we're talking about, the Daily Wire did cover the same story about the new defamation lawsuit, but they also covered the case in the past and actually spoke to jurors who served on the case. Here's what the Daily Wire had to say. The Daily Wire previously reported on the details of Khan's case. In March 2018, a jury found him not guilty in a court of law. While some could argue that not guilty does not mean innocent, some jurors said they perceived him as innocent after the trial. Quote, "He's innocent, and the facts prove it," said Elise Weiner, an alternative juror who saw the same evidence as other jurors. Quote, "He was acquitted because he deserved to be acquitted, and the prosecutor should have never brought the case in the first place." It's a good point of reference because now we know who and what we're talking about. In this new lawsuit, filed in Hartford Superior Court on May 14th, accuses 15 domestic violence and assault survivor groups of publishing knowingly false and defamatory information about him when they called him an assaulter in an amicus brief filed in 2022 with the Connecticut Supreme Court, years after he was cleared of all assault charges. Quote, "Despite the jury's verdict of not guilty, defendants, organizations with assets exceeding $200 million, and an experienced attorney repeated allegations as facts, according to the complaint." And let's also talk about what defamation is. If I have something really bad to say about you, or you have something really bad to say about me, it's got to be the truth. If it's the truth, it's an absolute defense. From findlaw.com, is defamation okay if it's true? To be defamatory, a statement must be false. Truth is an absolute defense to a defamation claim. In 2019, Yale expelled Mr. Khan after conducting its own Title IX investigation and finding him liable for assault. A native of Afghanistan, Mr. Khan sued Yale and his Jane Doe accuser for $110 million in a defamation case that is making its way through the Second United States Appeals Circuit. So that case is not resolved yet. The defendants in Mr. Khan's new lawsuit are 15 women's organizations that filed an amicus or expert brief in support of Jane Doe in the Yale assault defamation case. In that brief, they call Mr. Khan an assaulter, and there's a sentence that says the plaintiff assaulted her. Now, an amicus brief can give advice to the court on matters that the court might not be aware of. The court is very knowledgeable, but an expert in a certain area could say, "Hey, have you seen this case? Have you seen this information that directly relates to what you're looking at?" What is the purpose of an amicus brief? Of Latin origin, meaning friend of the court, an amicus brief is a written argument that seeks to help provide input and outside information to the court. Often, the brief is used to provide expertise that the judge or justice may not have at their disposal. And they also cite other cases. What's put forward in a brief is supposed to be well-documented information, as if the plaintiff or the defendant would file it. It's not supposed to be theory or conjecture. It's supposed to be facts. Other similar decided cases, for example. It's not there for people to file their opinions or to try to make irrelevant arguments that are not backed up. The Connecticut Supreme Court rejected the amicus brief from the women's groups in 2022 until it was, as the court put it, quote, "shorn of all facts not supported by the record." The groups removed the assaulter language and resubmitted it, but the original brief is still available to download in the court's online filing system. The women's nonprofit groups also shared the brief with supporters and donors. They also used their draft briefs to try to raise money. They had it on their websites, the women's groups. So rather than just use it to forward the case and put factual, documented evidence or relevant cases in a filing with the court, they made false accusations and then used those amicus briefs to try to raise money. Quote, they're literally calling me an assaulter. It's not ambiguous, Mr. Khan tells The Sun on the brief. Quote, the scarlet letter of being branded an assaulter is following me everywhere. When does this stop? And of course, it'll never stop. It doesn't matter how this case gets resolved. I certainly hope this guy gets the justice that the court system feels he deserves, and he should keep fighting until he gets it. It's going to be years and years and years. But it's important that the precedent is set that you just don't do this. You don't file false things either to raise money or to raise awareness for a cause. You can't do that to human beings. It's absolutely wrong. Mr. Khan is hoping to make all of this stop through precedent-setting lawsuits. He's suing these groups and the attorney who wrote the brief, Jennifer Becker, for defamation, spreading knowingly false information, emotional distress, and abuse of the court system. There is no specified amount of damages. Mr. Khan's attorney, Alexander Taubes, tells The Sun that one of the defendants, Legal Momentum, had a link to the brief on its website for some time. The women's organizations also sent out fundraising pitches with the brief. He calls this an abuse of the amicus, or friend of the court brief, legal process. Of course it's an abuse of the process. That is not the purpose of an amicus brief, not to raise money for your organization. Yes, it's salacious. Yes, it's exciting. Yes, it could justify to donors, oh wow, you're doing this legal work? Here's a check. But to knowingly put false things into a brief like this, to accuse a guy and name a guy of being something or doing something he did not do, and raise money off it. I mean, you have to have some accountability for this, or it's just going to happen nonstop. Quote, ordinarily, an amicus brief would be entitled to what we call in Connecticut litigation privilege, or also known as absolute immunity, according to Mr. Taubes, who told this to The Sun. Quote, but these defendants disseminated it widely outside of court in an effort to raise funds for their organizations, and those statements and publications are not afforded any immunity. Quote, they raised a ton of money. They just tell their donors, hey, we called some poor schmuck an assaulter. We're healing the world, Mr. Khan says. This case comes as President Biden's new Title IX rules are set to go into effect August 1st. Mr. Khan garnered attention last June when the Connecticut Supreme Court ruled that his accuser was not immune from defamation because his Yale Title IX trial was so devoid of due process protections, it could not even be considered quasi-judicial. The August 1st Biden Title IX rules will revert to a similar system of lax due process protections. A quasi-judicial process will give people immunity from being sued from what you say and do when you participate in that system. But Jane Doe, which is the pseudonym for the person that accused Mr. Khan of assault, was part of a process that didn't give him any basic due process rights. He didn't get a chance to confront his accuser. He had an attorney, but his attorney wasn't allowed to ask questions of the accuser. So because it was such a kangaroo court situation, the person who accused him is liable for what she actually said about him. And that's why he's got a $110 million lawsuit pending against the accuser and against Yale University. Mr. Khan says he wants first and foremost to clear his name. He also wants to get colleges out of the Title IX misconduct investigation business and change how assault allegations are adjudicated in the American justice system. He said he has a 4-point plan that involves getting rid of pseudonymity and immunity for accusers, protecting false accusers, and awarding large jury settlements. Earlier this year, Mr. Khan disclosed the name on Twitter of the Jane Doe who accused him of assault nearly a decade ago. Pseudonymity is traditionally given to accusers for protection. The Sun left a request for comment on the voicemail of Ms. Becker, the lawyer Mr. Khan is suing, but has yet to hear back. The Sun also contacted the other 15 defendants in Mr. Khan's suit. Only one responded by the time of publication. What they responded with was, we don't have anything to share at this time given the pending litigation. And in the Daily Wire's original coverage of the original incident, a jury acquitted him on all charges, but Yale still expelled him. Now he's suing the school and his accuser. Colleges and universities have a lower standard of proof than the American legal system when it comes to allegations of assault. This means that a student who is charged with assault-related crimes but found not guilty by an impartial jury can still be expelled from his school. You can be found not guilty and you can still be expelled by your school. That's what happened to Khan. The difference in proof. coupled with an inherent bias in adjudicators who are trained to believe all women, #MeToo, makes it easy for colleges to expel students based on less evidence that is presented at trial. This is what happened in the case of Saifullah Khan and Yale University. In March 2018, Khan was found not guilty by a jury in a court of law. Elise Weiner, an alternate juror, and main juror Jim Galullo said they didn't believe Khan's accuser. At one point, prosecutors showed a still frame from surveillance footage that appeared to show Mr. Khan holding up his accuser. Prosecutors claimed this was evidence that the accuser was too drunk to even stand on her own, and that Khan had to practically drag her to her dorms. The defense, however, played the actual video from surveillance footage, which showed Mr. Khan and his accuser walking arm in arm and appearing to be a happy couple. That is how every moment on the evening of the alleged assault played out in court. Prosecutors spun everything as evidence that Khan was forcing Jane to do what she did. For example, prosecutors claim Khan took the accuser's phone at one point. In reality, he was helping her find a ticket for a concert they were both attending. Khan was found not guilty and returned to Yale, but he still faced a pseudo-trial at his university. The Yale Kangaroo Court found Khan responsible for assault and expelled him. Many of the same people involved in Khan's expulsion have been involved in other misconduct trials for accused students who were also found responsible based on flimsy evidence or when there was exculpatory evidence. Khan is now suing Yale. In court documents reviewed by the Daily Wire, one of the named persons being sued by Khan is David Post, no relation to me. Post was the Yale administrator who convinced the student to file formal allegations against the former Yale basketball star Jack Montague after another administrator falsely told the woman that Montague had assaulted another woman on a previous occasion. Khan was born in a refugee camp in Pakistan 6 months after his family fled Afghanistan to avoid potentially being killed by the Taliban. He grew up in and around the refugee camp before fleeing to the United Arab Emirates. Khan, a bright student, applied to Yale and was accepted, but suggested he attended the preparatory Hotchkiss School in nearby Lakeville, Connecticut, before he went to Yale. Khan accepted a full scholarship to Hotchkiss and Yale. Prior to attending Hotchkiss, Khan hadn't even learned to use a knife and fork. Khan was allowed to return to Yale after his criminal trial. Yale administrators then suspended Khan, quote, for your physical and emotional safety and well-being and/or the safety and well-being of the university community, according to a letter from Yale Dean Marvin Chun. This suspension, like the first, left Khan homeless and threatened his status in the U.S. This second suspension also caused him to lose his university health insurance. Yale suspended Khan even though he was acquitted of the first accusation, and the second accusation came from someone not affiliated with the university. Khan is suing Yale for $110 million. In a statement to the Daily Wire, Khan's attorney, Norm Pattis, who defended him during his previous trial, said this, quote, the state charged Mr. Khan with every applicable variant of assault. Jurors acquitted him quickly of each and every charge. Jurors told us afterwards they did not believe the accuser. The jury got it right. Yale got it wrong. We're out to correct this injustice. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.